morning. Thank you for participating today. My name is Andrea DeLulio, and I'm president of the UB Law Alumni Association's Gold Group. Thanks for joining us for today's presentation, Business Disputes in Bankruptcy Court in the Era of COVID-19. This is one in a series of many programs that the Law Alumni Association is hosting as a service for our alumni and our law students. On July 17th at 1 o'clock, we will be hosting a free CLE open to all titled How to Access Free or Low-Cost Legal Resources for COVID-19 Related Matters. And that will be presented by our very own law librarian, Nina Cassio. If you're interested in attending any other upcoming webinars or CLEs, you can register at the UB Law School website. And you can also listen to past CLE presentations and other webinars that we've recorded at no charge at the new alumni education webpage. I'd like to thank our Gold Group sponsors who have helped put on programs such as this one, including AXA Advisors, Chicago Title, Counsel Press, Find Law, Jack W. Hunt and Associates, Precision Resolution, and Paramount Settlement Planning. A few quick administrative matters. You will be muted during the course of the presentation. If you have a question at any time, please use the chat room and we will try to address those questions cumulatively at the end. You can send any questions to me directly in the chat room. At some point during the course of the presentation, a course code will be announced. It will also be placed in the chat room in case you miss it. Make sure to catch it. You'll need this to complete your attorney verification form, which can be located at the registration page. You'll also need to complete and return the program evaluation form that's also found on the registration page. It is now my pleasure to introduce and thank our speaker, Bill Savino. Bill was a member of the class of 1975. He is a past president of the Law Alumni Association, and he currently serves on the Deeds Advisory Council. Since graduating in 1975, Bill has been litigating in pretty much any court that will have him. That includes state court, federal court, court of claims, tax appeals bureau, and importantly for today's presentation, bankruptcy court. I'd be happy to go into the many other accomplishments that Bill has had through the course of his career, but I think he'd really just like me to share with you that he plays in a jazz group that performs every Monday night on the rooftop of Tapo, and would like me to invite you all to come see him play. So without further ado, I give you Bill Savino.
Thanks, Andrea. And Andrea works with us, and in the 45 years that I have been practicing, I've never been around anybody who writes better than Andrea. Just the best legal writer I've ever seen. Bankruptcy, pandemic, bankruptcy, these are very serious subjects. So I decided to dress accordingly. Let me start by talking about how the courts are dealing logistically with the pandemic. I'm going to use yesterday as an example. I had a trial yesterday, successful outcome in the Southern District of New York, federal, not state. That means there were audio-visual people to help real techies, and the court actually adjusted for the aborted attempt in May to switch to better technology now. Very interesting. What the court did was, the initial attempt was a combination of Skype for the people speaking and then court solutions for the audio. So we would talk through the Skype, listen to the court solutions. It was dysfunctional. Wisely, the Southern District said, we're putting everybody on Zoom. We're just doing the basic Zoom. When the speaker speaks, the screen kicks in. Everybody has to be disciplined about hitting mute. And we were set to go with 7 witnesses. And I was pleased and disappointed that we won on motion after 2 hours of argument. So I never got to my first witness. But we had actually, watch what they did with the feds. They were very serious. They did a dry run for the May attempt, and the dry run was so bad, court canceled. They did a dry run for yesterday, and things went well, so they went ahead. So with the feds, we're seeing sophistication, efficacy, planning, adjustments to technology. Now let's talk about state court. There have been attempts to do appearances via Zoom in state court. So far, I've not had any of the state court attempts at Zoom succeed. The last attempt at Zoom, as panic set in, I said, guys, let me just send you my call-in number and we'll use my call-in number. And it was a big conference call. We were getting echoes, we were getting dysfunction. So we are going to get through this, but you got to really anticipate your needs. Let me give an example. When we did the dry run for the Zoom trial, Narottam Rai, the AV guy, said, Bill, pull your drapes down so the visual is okay. So you start to learn these things that they tell you. This mute button is life and death. Okay. Now, that's what I think I need to tell you about how things are going in state court and in federal court. But let me add, His Honor Judge Buckeye, with my buddy Bob Feldman, conducted 2 hours of argument on one case. So the conference call setup is working. My understanding, I'll watch my chat room. My understanding is that conference was just audio, no video. But remember, with the video, with the Zoom, it's set up so that if you speak, you go on screen. And it's sound sensitive, so you got to keep your microphone open. Now, let's talk about the materials. Gary Graber graciously allowed me to crib his materials and include them in what we circulated. So thanks to my dear friend Gary. Bernie Schenkler, who works with Andrea and me, gathered other materials, and those are wonderful as well. I've already got a question from Susan Bring about chapter 13, and I'm going to admit when BAPS CPA, the 2005 amendment, came out and put restrictions on representing consumers, I got out of the chapter 13 business. So I haven't touched that for 15 years, and I'm going to apologize. I don't want to speak where I'm not competent, so I'm not covering that. Now, I thank Bernie. Thank you, Andrea, for attending to the arrangements. Let's talk about how Congress inadvertently made things easier for the small businesses we're going to see going bankrupt this year. Yes, Brooks Brothers filed this week, but I'm going to tell you who we're going to see filing. The smaller retailers, the smaller restaurants. These are the people that are in our community. For those of you, and I see the names, we have a lot of people who do not routinely do bankruptcy. For the big cases, 90% of them are in the Southern District or the District of Delaware. We don't see those cases in Buffalo. You don't see, Tops wouldn't even file here. Tops found a way to get down to the Southern District. So we're going to see the smaller cases that are most likely to show up under this new subchapter 5, just created in August of 2019, just became effective late in February of this year, called the Small Business Reorganization Act. And this is timely. I'm not sure how it's going to work because there are some restrictions that make it in some important ways harder, despite the very many ways it makes being a debtor easier. Now, this new subchapter 5 for small business reorganizations modifies or eliminates many traditional Chapter 11 requirements. The idea is making it easier for small businesses to confirm plans of reorganization and owners to retain equity and control. It is an easier thing for somebody to handle so that if you're not doing this day in and day out, I think you can take a chance and try to do a subchapter 5 case. Now, here's the interplay between the Small Business Reorganization Act and COVID. The CARES Act for 2020 changed the debt limit on subchapter 5. Before, the debt limit was $2.7 million. Now you can file subchapter 5 with as much as $7,500,000 in non-contingent liquidated debt, excluding debts to insiders, excluding debts to affiliates, as long as not less than 50% arose from the business. Now, when you think of a business, the vast majority of the businesses in Buffalo have less than $7.5 million of debt. And what's good is by knocking out the non-contingent, the unliquidated debts, that means if you got sued on a slipper fall for $100 million, that doesn't disqualify. It doesn't count towards the limit. So this is going to pick up the vast majority of restaurants and retail that are based in Buffalo. Now, because of the temptation to abuse access to subchapter 5, there are actually procedures for creditors to say you don't belong. If you file, there's 30 days after the first meeting of creditors where you get a chance to interview the debtor, 30 days after that first meeting of creditors to object and say, hey, they really have more debt than is allowed. Hey, a greater proportion of the debt is personal, not corporate. If you convert in from another chapter, again, it's 30 days. Now, there is some balancing in this law between favors for the debtor and favors for the creditor. There are some basic protections that subsist under subchapter 5. One is, and it's the most important, the best interest test. And I'm going to come back to it. But simply stated, to confirm a plan in subchapter 5 over the objections of creditors, you have to show that they are receiving in the distributions under the plan of reorganization at least as much as those creditors would get in a straight liquidation. So that's basically a way to make sure that chapter 11 doesn't give them a bargain on what they would lose in a chapter 7. But remember, when that analysis is done, you take the assets through the waterfall. You have the exemptions, you have the secured creditors, and then when you get to the bottom class, the general unsecured, you take a look at what the plan is proposing, what a chapter 7 would distribute. Okay, another thing that still subsists under chapter 11 is often discussed, rarely used, and everybody writes law review articles on it, and I've seen it twice in 45 years. The 1111B election. And if somebody shoots me a text on having seen 1111B election locally, I'd love to hear that this is something more than a unicorn. But in an 1111B, the secured creditor says, hey, I will give up my unsecured claim, keep my lien, and then there's this exotic formula of net present value that I will reach if I have time later. Okay, so the law went in and effect just February 20th. So we have had, I mean, this is the joke, we've had 4 full months under this new law. So there's very little case law. We're all guessing about it. Now, there are still certain restrictions beyond the generation of the debt and the amount of the debt. You cannot use subchapter 5 if you have one piece of real property. There's a special provision in the bankruptcy code. That's the single asset debtor, and that's where you go if you have one piece of real property. But you see the clever guys in Manhattan add a second parcel just to make sure they don't get stuck with the 90-day deadline in single asset debtor. Simply, within 90 days, you either propose a plan or start paying debt service. So those single asset cases are no fun. But let's go back to subchapter 5. There are a lot of changes that take place early in the case. Now watch. I graduated in 75 and I've got some classmates out there. Seems like yesterday. So when we graduated, we were under the Bankruptcy Act. The Bankruptcy Act was basically the Chandler Act from 1938. I looked at the legislative intent, and testifying to Congress was the later Senator Jacob Javits, who was a Chapter 11 lawyer at the time. So that law was there when we graduated from UB. Then the Bankruptcy Code came out, and one major theme of the Bankruptcy Code is we don't want the judges meeting ex parte with debtors. And that was the policy that went into effect for 4 decades. Now, suddenly, here in subchapter 5, meetings with the judge are mandatory. Meetings with the judge, but not with creditors, are now mandatory. This is a sea change. And I think some judges are going to be uncomfortable with what they say and being candid. That conference with the court to make sure you're on track has to transpire within 60 days of the filing. 14 days before the meeting, you have to get a report of where you are. And the reason for this conference is the tight timetable on proposing a plan of reorganization. 90 days. I have never proposed a plan of reorganization that got confirmed within the first 90 days of a case in my life. And again, I invite anybody to go in the chat room and say, oh yeah, I confirmed a case, confirmed a plan I filed within 90 days. So the deal with the devil is you get all this streamlining I'm going to discuss as a debtor, where you can economize and have less burden, but you got this sword of Damocles, a 90-day deadline for your plan submission. Okay, now, during the 11 itself, here are some of the things that are pro-debtor. Only the debtor can file a plan. Now, notice this. Under your traditional Chapter 11, you have an exclusivity period. The exclusivity period can be extended. Your exclusivity period always lasts more than 90 days anyway, so this sounds like a great deal, but you would have been the only one as debtor to be able to file a plan within the first 3 months anyway, but it feels good. Okay, the only way you extend the 90-day deadline for the plan, listen to this, circumstances for which the debtor should not justly be held accountable. Is that the pandemic? I don't know. Is that a fire? I don't know. We have no case law under this really to flesh out these things. Now, here's something a small debtor is going to like. Instead of paying quarterly fees to the Office of the United States Trustee, and these can be burdensome, they're based on disbursements. So if you're a restaurant, not a restaurant, if you're a grocery store, your quarterly fees relative to your gross margin, they're significant because it's revenue driven. You don't pay your quarterly fees to the Office of the United States Trustee, and the Office of the United States Trustee is not your watchdog. But there's a trade-off again. When you file your plan, if it's non-consensual, if you cram down a creditor, if every class of creditors did not vote yes, then you actually have to dedicate to the dividends, to the distributions to creditors, all of the debtor's disposable income for at least 3 years and subject to the extension by the court up to 5 years. Now listen to what you must dedicate to creditor settlements, to creditor repayment. Income that is not reasonably necessary to be extended for continuation or preservation of operation of the debtor's business, maintenance or support of the debtor, or domestic or dependent support obligation. So that's a very large component that's got to be locked in and dedicated to creditors. It's basically your operating income. Now, instead of having the United States trustee as the watchdog, instead of having the quarterly fees to the U.S. trustee, watch this new program. And I know people have applied for it. They're going to have a standing trustee appointed in every subchapter 5 case. This is very different. Let me give you the classic. In a chapter 11, you have the United States trustee as watchdog, but not active in operations. And you only have a trustee that touches operations if management gets ousted for fraud or gross mismanagement. Gross, I mean, you already have mismanagement. You're in bankruptcy. Gross mismanagement. So in a chapter 11, you're either barely supervised or you're gone. You are taken over by the case trustee. Instead, with these subchapter 5 trustees, they are business people who try to help you put together a consensual plan. And watch this. If you cram down your plan because you can't get, for example, unsecured creditors, trade creditors to agree to your proposal, that standing trustee actually handles your cash and distributes it. He takes your dividend money and sends it out. Very, very sweeping. Now, let's talk about plan confirmation. Okay, I got to do a little history here. There is a reference in 1129 of chapter 11 that says the plan has to be fair and equitable. The courts, going back to the 30s, put a gloss on this called the absolute priority rule. What's the absolute priority rule? Under the absolute priority rule, if you cram down a dissenting class, a class that doesn't vote for the plan, then ownership gets transferred to that class. Well, you can see as a small business owner, you're sitting with your lawyer, you say, hey, how do we make the unsecureds take 20 cents on the dollar? And the lawyer says, cram down. And the debtor says, well, is there any bad news? Yeah, you lose ownership. So that's one of the problems. Now, this gets really confusing. Around 1940, there was a footnote in a case called Case versus Los Angeles Lumber, where I think it was Justice Douglas said, well, maybe we'll let them keep their ownership if they make, in effect, a contribution. So we had more cases on that. The Supreme Court said, well, we're not officially saying there's an exception to the absolute priority rule, but we know at least a promise to work for free, a promise of sweat equity doesn't get you out of the absolute priority rule. So if this farmer lost his farm because all he could promise to do was work at it. Now, we still don't have a clear decision saying it continues to exist, and the Supreme Court does these footnotes that say we're not deciding. But here's the basic rule. If you make a contribution as an insider, as an owner of a corporation, and you put in fresh cash yourself, and that fresh cash is at least the enterprise value of the entity less the debt, especially if it's market tested, that will suffice for you to keep your business. Well, if you're some guy or woman in the pandemic with a bar and you're tapped, you've been living on your savings, you don't have the money for fresh cash. So if you knew you had hostile creditors and you knew you were going to do the traditional Chapter 11, you would be worried that the absolute priority rule would wipe out your ownership if you had to cram down a dissenting class. So now, if you fit this small business debtor, the subchapter 5 debtor, then the rule regarding absolute priority gets changed. The absolute priority rule is eliminated as long as you satisfy the disposable income test, which is, that's a burden. You're basically giving up all the operating income, as long as the plan does not discriminate unfairly. I'll talk about that. And as long as it remains otherwise fair and equitable. Now let's talk about discriminate unfairly. Let's say I have trade creditors and I have a restaurant. I have SLA liquor stores that sell me money, and I run an open tab at Dash's Grocery. So I put the Dash's Grocery in the general unsecured, and I pay them 25 cents on the dollar, 5 cents a year over 5 years. But I put the liquor guys, who I really need to be friendly, in a special class and give them 100%. That would be an example of unfairly discriminating. Personally, I pay my liquor guy 100 cents. Take my word for that. Now, here's another thing that's a real pain. Unless a particular administrative claimant, post-petition claimant, basically a claimant of the debtor entity, waives payment at consummation, when the Chapter 11 plan gets consummated, you got to write that person a check. So let's say I'm the attorney, I built up a big balance, it's 50 grand or something. I can say, I'll take it, $2 grand a month, right? But if it's some other administrative claimant, like your landlord for post-petition rent, you can't force that party to wait. So now they are changing it that you can stretch out your administrative claim payment for 3 to 5 years, the same 3 to 5 years for the disposable, base 3, expandable by the court to 5, and that way you can get some relief. So I've seen cases that build up a lot of administrative claims. That's a fancy name for any debt generated after the date of filing. It could be just supplies. Okay, now, one of the big expenses of a Chapter 11 is eliminated by subchapter 5. This is called the disclosure statement. Let me give you some history. One of the reasons I like the history is I remember when the bankruptcy code got rid of the old Bankruptcy Act and all the debate that went on. And I met Ken Klee, the author, and it's interesting because publicly traded companies could file Chapter 11. The Securities and Exchange Commission said, guys, when a debtor settles up with creditors, those creditors are really involuntary investors in this company. They are involuntary investors, so you should treat them like investors and give them a prospectus. Give them the disclosure that you would get in a registration statement. So the compromise passed in 78, effective 79, was we are going to have every plan accompanied by a separate disclosure statement that has basically the same stuff you see in a prospectus. History, ownership of the insiders, litigation, how you're going to go forward, things like that. And then that had to be approved by the court for adequacy of disclosure. That would be a separate battlefield. I had a battle in Connecticut with what was then the biggest Chapter 11 in that state. We went through 8 separate disclosure statement hearings until the judge finally said, we're going to put in your disclosure statement, he said and she said, where it was going to give our version and the largest creditor's version, and they would both be stated. And that was the only way we broke the impasse. Disclosure statement eliminated by subchapter 5. So there's none at all. That whole battlefield, those hearings over adequacy, those disappear. But look what is required in your plan. So it's essentially consolidated, like you can do in small business cases. In the plan, you have a brief history of the debtor's business, a liquidation analysis, and projections with respect to the debtor's ability to make plan payments. Now let's talk about the liquidation analysis. You need a liquidation analysis to be able to determine whether the best interest test is met. Because remember, the best interest test is it shows that creditors are getting more through the reorganization than they would through a liquidation. And in a liquidation analysis, you might say, okay, we've got accounts receivable of $1 million. We figure on liquidation, you'd collect $700,000 because you don't get 100 cents when the business is closed. Let's say we have $2 million of inventory. Well, a lot of that is work in process. It's worthless. We've got some raw materials we can resell. Let's say on liquidation, that's worth $400,000. That's the kind of analysis you would see. Now, here's a big thing. The bankruptcy code has all these restrictions on debtors modifying mortgages on their residence. And quite simply, the bankruptcy code has been affected by lobbying. Certain groups have been more effective lobbying than others. The granaries, I don't even know where there's a granary. Granaries get special treatment. Fish processing plants, there's a big lobbying group. They get special treatment. Well, on your house, your mortgage can only be modified in subchapter 5 if it's not a purchase money mortgage, if the mortgage went on for you to put money into the business. But that's a big deal because otherwise there are huge restrictions on doing anything with the personal mortgage. Now you got to understand that the case where you would have an individual debtor might be a physician who didn't form a PLLC. If I'm a psychiatrist, first thing I do is treat myself. But if I were a psychiatrist and I file, my house is one of the assets in the Chapter 11. Okay, now let's talk about cram down in detail. The basic voting continues as it was. If it's an unsecured class, you need 2/3 in dollar amount of those voting and a majority of those voting, and then the class is considered supporting and the dissenters are bound. Let me give an extreme example. You owe $1 million of trade creditors, 100 trade creditors. Nobody bothers to ballot, right? One guy owed $100, votes yes. That class is bound. You only look at who ballots. But watch, if you've got one creditor who's over 33.3% and that creditor is not on your side, if that creditor has counsel and you know that creditor is going to vote, that's a veto right now because you can't get your 2/3 in number. Now, in regular Chapter 11 cases, one of the ways you get out the vote is you go to your creditors committee and you say, guys, negotiate with me. And you cut they feel they cut their best deal and they send out a letter that you add to your reorganization package that says, we've beat the doo-doo out of the debtor. We can't get any more money. Take it. It's the best you're going to do. And that letter is precious. There's a lot of horse trading to get that letter. So now you don't have a creditors committee in a small subchapter 5. That saves money. You don't have a creditors committee appointed. You don't have to pay their attorney or their accountant. That's good. But without a creditors committee, who is trusted by the creditors to get the support for your plan in their ballot? And I'm going to tell you, I've been in a competing plan situation down in Florida. It was over, fields and fields of peppers and cucumbers. And what we did was I took a bunch of summer associates with a script who called up the farmers and actually solicited ballots, and we won the ballot fight. So now this is going to be very tricky where you don't have the creditors committee. Essentially, the debtor very carefully has to solicit that support. Now, I told you how the vote works. 2/3 in dollar amount voting, bare majority of those voting. Let me point out, if you had a bond category where you have all different bondholders, it'd be the same thing. Debtors this size are going to have one or two institutional lenders and trade creditors, maybe the IRS. Now, so what you've got to do is, if you open up the ballots, let me give an example. PermClip had its confirmation hearing this week, didn't have the ballots. My client voted no. Dan Sarsinski's client voted no. Seth Hibbard's client voted no. So they had problems with the ballot. So these things happen. So if you have this subchapter 5 category, then you can do the cram down at a cram down hearing where you show the liquidation value, You promise the disposable income, and I hope you're not discriminating unfairly, and I hope you're fair and equitable otherwise, other than the elimination for subchapter 5 of the absolute priority rule. There will not be a test at the end of this 1 hour. I know this is a lot of information, but I do want to try to get through it. So here's an interesting thing. I got this case going in Wilkes-Barre, Pennsylvania. That town is depressing. And the plan, I've got the largest secured creditor, and we're worried about getting crammed down until we settled. Watch this. The debtor proposes 99 cents to the trade creditors. My brilliant client says, why is it 99 cents and not 100 cents? I said, they're setting you up to get crammed down. Under Chapter 11, generally, you need at least one impaired class voting yes. If they get 99 cents, it ain't 100. They're impaired. But everybody votes for 99 cents. It's an old BK lawyer trick. So by doing that, he's got his one affirmatively voting class. Okay? Now, you don't need that for subchapter 5. You don't have to sell out to get one class voting yes to do the cram down. Okay, I'm going to talk about the 1111B election. If you're a secured creditor, and if they argue you are undersecured, the collateral is worth less than the value, the collateral is worth less than the amount due, you are undersecured. In Chapter 11, this is a hard concept, your claim is bifurcated. It is a secured claim that has to be paid 100 cents plus interest, and an unsecured claim that can get treated like the general unsecured with a discount. So watch what that means. You might get 10, 15, 25 cents on the dollar on the unsecured part, and you get your 100 cents and interest on the secured part. If you think that parcel is going to appreciate, if you think that collateral is going to get resold, you waive your unsecured part and you do the 1111B election. And that's where this formula, your heads are going to explode. I want to be able to see it. You have to be paid over the length of the plan in gross dollars, the full amount of your principal debt, but the amount brought forward into a present value has to equal your secured portion. So watch, if you have $1 million debt, if the asset's worth $100,000, over time you have to be paid $1 million, but the present value of the cash stream has to be $100,000. It's basically a 20-year plan. It's crazy stuff. I've seen it twice. Okay, but the advantage is, if you think that parcel is going to go from 100 grand to $1 million with regentrification or development, you want to keep your lien, and that way you get paid on any sale. Now, let me talk about some other things here.
Hold on, but before you continue, I just wanted to announce that the course code is dispute, and I will also add that to the chat. Go ahead.
Sounds good. If anybody's sending me questions in the chat, I'm going to read them at the end. I'm going to tell you, just as we start to leave this area, there are all these good things for the subchapter 5 debtor. No creditors committee, great. No quarterly fees to the U.S. trustee, great. No disclosure statement, great. No need for an affirmatively voting class, great. No being wiped out of equity ownership by the absolute priority rule in a non-consensual confirmation, all this good stuff. But you got to confirm in 90, you got to do your plan filing in 90 days. Watch this. If I file for my restaurant in March of 2020, right? This was available then. March of 2020, March, April, May. In May, I'm not even reopened. How do I make a proposal projecting disposable income with any confidence? Let me describe. In a typical bootstrap, where the debtor actually retains its own business, where the exit is not funded by a sale of the business, where the case rehabilitates instead of liquidates. In that typical case, you got to change the business. When I did the reorganization of Shaner Electric 40 years ago, what we did was we went out of supplying contractors, just exited that business, restructured how we did business, and went from huge losses to solid profits. That's the kind of thing that you don't do in 90 days. When I reorganized WHLD and WZIR, we sold WZIR, got out of FM, stayed in AM. Then we were running a profit in AM. How do you do a structural fix in 3 months? Unless you've already done the fix and you file with the fix done. That's not the typical businessman. The typical businessman files his case virtually at the trough of the curve. So I worry about that 90 days. Now, let me go into a fascinating COVID issue. We know the CARES Act, besides raising to $7,500,000, the debt cap for eligibility for Subchapter 5 also implemented the PPP plan, the Paycheck Protection Plan. Now, this is fascinating. It's administered by the SBA. There was very little said in the law, and the SBA has been issuing waves of regulations. I think it's up to 4 separate waves of regulations. So early on in the regulations, the SBA said, in your application, you have to certify you're not in bankruptcy. Now, if there's somebody that needs a PPP loan, it's someone in bankruptcy. Listen to this. Yesterday, in court, on Zoom, fighting over this real estate in New York City, my opponent said, don't convert me to Chapter 7. Dismiss the case. I become PPP eligible. I'll borrow the money I need. Didn't convince the judge, but notice the interplay between the inaccessibility of PPP loans to a debtor. The SBA, in its regulations, still has the requirement you certify that you're not in bankruptcy. There have been various cases. Hidalgo, down in Texas, trial court said, you know what? We're making the SBA lend you the money. In Buffalo, the Diocese of Rochester and Buffalo moved in court for an injunction. And Her Honor, Judge Wolford, wrote a wonderful 11-page decision. I love that judge. So you got to look at her decision. First of all, she says, and she's not a BK lawyer. She was a pure commercial litigator like her UB grad dad, Mike. So watch this. She starts off, a gentleman, you're citing to Section 525 of the Bankruptcy Code that says governments cannot discriminate based on bankruptcy. Therefore, this is a case arising under the Bankruptcy Code. This case belonged in bankruptcy, and you should have said, if you wanted me to decide to get the injunction powers, to withdraw the reference from district court to bankruptcy court to get it back up here. But even though you guys didn't remember to do that, I will sua sponte on my own as judge, withdraw the reference so I can make the decision. You know, that was, very astute by her to pick that. So she said, look, this is all under the Supreme Court's 1984 Chevron decision. We have to talk about what deference gets given an agency. And it's a beautifully written decision. She says, look, let's go back to Chevron. Chevron says if the law from Congress is silent or ambiguous, that allows you to get to the second step. If the law speaks to the issue at hand, stop, follow the law, not what the agency says. But if the law leaves a vacuum, then we look at what the agency did. And she said, you know what? The word bankruptcy isn't in there. You look at the CARES Act, it's not there. I can't tell what the Congress intended, so now it's up to the SBA. And then the question becomes whether the agency's interpretation is a permissible construction. Now, determining whether it's a permissible construction requires a couple of subtests. Is it arbitrary, capricious, or manifestly contrary to the statute? Is there a reasonable explanation for the policy? Here, the SBA said, look, we have hundreds of thousands of loan applications. We don't have the time in a pandemic to actually test which of these borrowers have the prospect of being able to repay if they do not fit the forgiveness paradigm. We can't do this. The easiest way for us to do this, to get money out to people in the middle of a pandemic, is have a bright line for bankruptcy. If you're in bankruptcy, you don't get the money. And is it harsh? Yes, but we don't have the time under emergency rule issuance powers to be granular and test each particular applicant for at least some prospect of getting repaid. So watch this. One of the duties of SBA generally for these SBA loans is to vet the borrowers to assure that there is a real prospect of being repaid. That's a general duty of the agency. And what Judge Wolford says is they are honoring their duty. In times of pandemic, they need to do some shortcuts. And I do not think picking being in bankruptcy is an arbitrary or capricious shortcut. And they've provided me an explanation as to why they're doing that. So she said, I think that satisfies me. Then the other alternative attack, not the Chevron attack, the other attack by the diocese to try to get the PPP loans, and millions of dollars are at stake, $1.8 million for Buffalo, $1.1 million for Rochester, and they could use the money. Attendance is down. The other attack was, Judge, this is discrimination by the government in contravention of Section 525 of the 1979 Bankruptcy Code. They're discriminating against us because we're in bankruptcy. What Judge Wolford said is, well, there are times when even the government is allowed to discriminate. And one of the times, according to the Second Circuit, is in respect of loans and borrowings and credit. For loans and borrowings of credit, they, at the government agencies, can still weigh the impact of the bankruptcy. So that's an allowed consideration, and we think that that's something that is not a violation, so we have no alternative grounds to force the PPP loans. Now, the diocese said, you're calling them loans, but they're going to be forgiven. Why do you care if we're going to be able to repay, whether under Chevron or whether under 525? And the judge said quite rationally, well, if everything goes perfectly, if you use 75% of the money for payroll and 25% for rent, utilities, and other operating expenses, you do get the forgiveness. But how do we know it's going to be there? And one of the things was the actual argument by the defendants, and the defendants here were the government. We worry that in bankruptcy, the money could be used for an impermissible use. That was not the real hook on which Judge Wolford hung the case. And I think their better arguments were, we don't have the time to analyze finances, and using a bright line test is probably the best. Now, Andrea, you know me, when I get done with my script, I'm done. Should I scroll down and look for questions? Because I've actually completed my full presentation.
Sure, you can take a look. I have one question someone submitted to me, and I welcome anyone else at this time who has questions to send them to me privately, and we can get those answered. So the question was, in regard to Small Business Reorganization Act, Subchapter 5, administrative expenses can be paid through a cram down plan. How do you think that affects creditors with an administrative expense?
Oh, that's a great question. The administrative expense has to be paid 100 cents. The only thing that happens with administrative expense is it gets termed out. So there's no power to discount. So when you sell to a debtor in subchapter 5, after the petition, while it is a debtor in possession, you have no risk of being forced to accept a discount at reorganization. Your risk is, will the debtor survive? Will the debtor rehabilitate? But your risk is not losing principal if the debtor comes out of reorganization. But you may have to wait for your money 3 years, 4 years, maybe 5 years. Technically, administrative expenses are not actually a voting class because you don't have the right to take away their 100-cent dollars. Interestingly, there's for those of you who are also accountants, I pretend to be one. I play one on TV. There's a wonderful standard operating procedure from the AICPA called 90. Wait a minute, it's called 90-7 or 90-71. And what it does is it sets up a different kind of accounting for debtors. Rather than GAAP, you have two classes of liabilities: debts subject to compromise, debts not subject to compromise. And that's really the test for a Chapter 11 debtor. Pre-petition, subject to compromise. Pre-petition secured, if undersecured, subject to compromise. Every penny of debt incurred on the post-petition balance sheet, not subject to compromise. I like how the AICPA changes its analysis for debtor in possession accounting. More questions?
Someone would like to know what socks you're wearing.
It's not gig day. I only wear my music socks on gig day. I take this very seriously. These are just blue socks because I'm not playing a show tonight. But
Basic
since you
blues.
mentioned it, at Tapo on the roof, we have plexiglass screens, reduced number of tables, all the staff wear masks. Rocco Termini is meticulous about making sure everybody is safe and feels safe. More questions?
Did you get any sent to you directly?
No, I'm checking. Lou sent me the socks. Somebody asked, here's one for you, Andrea. I did not retain the invite for the CLE. How do I get the affirmation and review forms? Where do I send them?
If you scroll up, Pat Warrington put a link where you can obtain the forms, and then you send them directly to her at her email.
Okay. And thanks again to Bernie. And I just plain called Gary and said, Gary, you did your materials on the CARES Act for March. Can I reuse them for the Gold Group? And he, of course, he was generous and courteous and allowed the reuse.
Well, thank you so much, Bill, for your
Here's a
time.
new question. Hold on.
Oh.
Let me check.
Scroll up in the chat. I'll send her message here.
Is it too early to start day drinking?
Well, it's Friday.
That's what I'm thinking.
I'm gonna say no. All right, well, thank you so much, Bill. We really appreciate it. Everyone, please remember to complete your attorney verification and evaluation forms and get those to Pat. I did just repost the link where they can be found. Again, as a reminder, the course code was dispute, which you will need to complete those forms. And I hope everyone has a wonderful weekend. Thank you again, Bill.
My pleasure. I had the most fun of anybody. Thank you.